back to Senate Economic Development, Housing and General Affairs. Some of us had to go up and honor Topper McFawn, one of our great legislators who's retiring today. And so we had to give him due honor. So, and this is plastic honor, I had to particularly there. But we now are lucky to have both the chair of the committee that brought forth H772 and the reporter of the bill and with us to answer a bunch of the questions that have come up and to address the intent and the work that has gone in behind a lot of this work. So without further ado, Mark Mahaly and the president, we welcome you. And Mark, if you would take it away. We have a lot of questions, but I really would love to have you address both the intent and the work behind our getting to this moment.
Sure. Mark Mahaly, pleasure as always to be with you guys. Thank you. Thank you for spending time on this.
Yeah.
This controversial and difficult. This bill is kind of the result of almost a year's work. Your chair and I, in the summer and fall, met with tenant and landlord advocates, and sometimes together, actually, put together and talk through a lot of the issues. And what came out of all of those discussions was this bill, which was attempting to balance concerns. I'll get to it later, but believe me, we did not address all of the concerns on either side of this bill. It's an attempt to move us forward in a status quo, which is not particularly desirable and really seems to be pretty bad for everybody. I think that maybe one way to look at this is what's in the bill for each group of advocates, and maybe what's not in the bill. The problem for landlords, we have a problem which is Vermont is not like a lot of other states in many respects, but one of them is the small size of the bulk of our landlords. We do have large landlords, and the largest landlords are our nonprofits, but the smaller landlords dominate, particularly in rural Vermont, people with 2, 3, 4, 5 units, etc. And their situation is that they're very discouraged by the status quo because it is so long and so complex to go through an eviction of a tenant who isn't paying, or a tenant who is destroying property, or a dangerous tenant who is selling drugs on the property. And in fact, our process is 2 to 3 times longer than our neighboring states. We really we're an outlier among states in how long it takes to go through the eviction process here. I don't think it changes things in the sense that someone who isn't paying eventually ends up out, but they just end up out 2 months or 3 months later than they would and at a greater cost. But the fact that small landlords are discouraged to the point where some of them are leaving the business, others are doing short-term rentals, and others are considering just not renting their units out after one bad experience is a problem because they're the providers of rental housing that people need. So that's a real problem. And one of the difficulties of this bill is that all the problems are real problems. It's not as if one side's right and one side is wrong. That's the truth. On the other side, obviously, there's one other aspect that I'm not going to characterize as a landlord. I think it's just a problem for both landlords and tenants, which is, as you know, we are suffering from an eviction problem in Vermont, and it's gotten a lot worse. And so we're having situations where one tenant is selling drugs on the property or being violent and causing real problems for other tenants, and the other tenants are demanding why can't you do something about this? We have a lot of correspondence from such things. And of course, the landlords are also frustrated as well. So on that side, what this bill does is the following. I have to say, I don't take it as a compliment, but I think that the things that this bill does, if it's somewhat exaggerated, it's not as much as it's been conveyed. On the issue of the tenants, the concern about the length of the process, right now the courts estimate their target is that it should take 6 months, to go through the process. And as I said, other states are sort of in the 2, 3, or maybe 4 months range. But this puts in one suggested deadline, which is to say that from the time you file your complaint until the time of the hearing is 90 days, 3 months. It was in our draft 60 days, but it was extended in judiciary to 90. I want to add something process-wise so you guys know what we went through. We produced the bill, and judiciary took it and held 2 days worth of hearings and included extensive consultations with the court, the chief judge of the courts. And they were concerned that the bill as it came out of our committee would consume resources that they didn't have. And so the judiciary changed it and eliminated the entire part of our bill that would have kept confidential proceedings until the landlord won. That's gone. And the other was extending it from 60 to 90 days and putting in every deadline that we did this. Judge Zone came to our committee and really had spent a lot of time going page by page through the bill. And we made every change she suggested. The biggest one was that all of the deadlines are now, they're a deadline except for just cause or due cause. So the court can always extend a deadline. And so after Martin Lalonde and others worked with Judge Zone in that committee, he withdrew his objections about it being too difficult process. So we now have the suggested deadline of 90 days. Without that, I would say this bill doesn't do very much to address the problem that landlords face. Except for one thing, and this is the other area, but I'm going to call the dangerous tenant. Okay. This is a big problem. I'm sure you'll hear from the nonprofits and from other landlords that they suffer from, but it's a tenant problem too. So what do we do there? What we've done simply is put in a process that a landlord, if they think this is an issue, when they file their complaint, they have to put together an affidavit under penalty of perjury, setting forth exactly why they think it's a problem. How do they know it? How do they find it out, etc. And then there has to be, then the defendant tenant has an opportunity to either do, well, not appear, for case that's that, or to appear, and as they already do generally, give their version, either orally or in writing. And the only difference is it's faster. The court has to hold a hearing within 21 days. There's no suggestion how long it's taken to make a decision. We can't, by the way, separation of powers. You know what I mean? The judiciary is a separate branch. We can establish deadlines.
Yep.
For hearing. We can't order them to make decisions. So we don't. We just put a deadline in, and that deadline is 90 days generally and 21 days for the faster process, unless there's just due cause, and then they can extend it. So there's flexibility built in, and that's what the judiciary wanted, and that's what we did. So there's one other, other thing we did. It's kind of a wrinkle. I hate to take you into the weeds, but I guess you're in the weeds. An additional problem is what happens when there's a tenant, I'm gonna use the drug dealer, but the language we use endangering the health or safety of other tenants on a continuing basis that they're likely to going forward. Okay, that's the way. But I'll use the drug dealer as an example. What happens if the drug dealer is evicted, but comes back and says to some tenant, hey, I'll keep giving you drugs if you let me operate out of your apartment, or I'll blow you away. You know, or they never were a tenant and they just come in. What do? Well, there was a Vermont court case that said, interpreted our existing law saying, well, there's nothing you can do. Invitee, if it's an invitee of the tenant, you gotta let them come on. So we work with that here, and in a way that judiciary and the courts are comfortable with, which is to say that the landlord's trespass authority includes someone in that situation, as long as the tenant didn't want them there and said so, or they are clearly violating the law, doing something illegal.
Right. That was the Decker Towers
The
challenge.
Decker Tower.
We haven't
situation.
heard so much
And
about that.
unfortunately, it happens a lot in Vermont. But those are the only ways that this bill addresses that whole side of things. There's nothing else in here that I can think of. So then there's the question, okay. So keep in mind those two deadline changes. Oh, we extended the time a little. There are other minor changes to deadlines. The answer is due like it always was in 21 days. There's one, when the landlord, you remember the whole thing starts, before you go to court, you got to give notice and say, I'm terminating. You with me? In other words, think of it as two phases. The landlord starts by saying, I want to terminate. It gives notice. And then if the person doesn't leave, then they gotta file.
Tom, to pass this, Pam just produced this for us, which was very useful.
Right. Yeah, the deadline. So some of the deadlines are changed a little bit in terms of the notice. But on the other hand, we linked this a little bit because the mail was no longer reliable. So we changed the presumption that after 3 days it's presumed received to 5. You know, so, but I have to tell you, these are minor in the overall scheme of how long things take here. Okay. So what about the tenant side of it? I want to clarify one thing to start, because there are terms being thrown around like no cause, just cause, and I'd like to just break those apart because I don't think they're particularly helpful and they're riddled with exceptions. Think of it this way. What are the different ways that a landlord would give a notice to terminate? Some of them are what I call the tenant is the moving party or the cause. It may not be their fault. And that would be non-payment of rent or the dangerous tenant, okay? All the others are in the landlord's control. I want to convert it to a condo. I want to remodel it completely and you can't be in it while I remodel. I want to use it for my family. I want to sell. Right? The lease is over and I just don't want to renew it. So all of those are in the control of the landlord. All this bill allows the landlord to, it doesn't change the status quo. The landlord can non-renew a lease for any of those reasons. What it does is it puts condition on it. And I want to say parenthetically, the just cause ordinances, both in that were adopted as charters but not approved by the legislature here, but around the United States, they're identical to the bill as it is, except in two respects. One is these ordinances take that one thing I mentioned, which is I want to let the lease run out. That one cause and says you can't do it. If I enter into a 12-month lease with you, you're my landlord, I enter into a lease that says 12 months. As long as I pay, it's not 12 months, it's forever. Under that approach, okay?
That's under just cause.
Under what's called just cause, but everything else in the just cause ordinances is usually allowed, and it is in Vermont. In other words, if I want to convert it for my family, I want to sell it, I want to, all those things I can do. But the one difference is letting the lease run out. Okay? Fortunately or unfortunately, it's a reality that those aren't very meaningful ordinances unless there's a rent cap or rent control. They kind of go together because think about it. If you have a law that says the landlord can't, as long as the tenant pays, the landlord has to let them stay, but there's no limit on what they can charge. If you were my landlord, you could say, sure, you can stay. Hey, an extra grand a month or whatever. So they're always paired with some sort of rent cap, et cetera.
But we don't have that.
We don't have that now, and under this bill, we didn't do that, okay? So let me tell you first what we did do. And then what we didn't do and some thoughts on it. What we did do, say, in those circumstances, what I'll call conversion, the landlord, in other words, not non-payment, but just the landlord wants to change their plans. The landlord is in control. So the requirements that we put in were, one, you got to give them 3 months notice, 90 days notice. That's one thing. The second thing we said is 45 days before the end of the term, you got to give them half of their deposit back. Net of damage they've done. But I'm thinking of the good tenant that isn't doing damage. They're paying their rent. They're a good tenant. It's just the landlord who's decided to change their plans. And we've said, you have to give them half their deposit back. Why? So they have some money to roll over to the new, and find a place and roll over into a new. So that's one thing we've done. There are two things that we've done. Now, we didn't put in just cause. The rest of it, we didn't put in a provision that says not only do you have to give long notice, and not only do you have to give half the money back, but you just can't terminate it. Why? Well, I mean, I guess it's important to speak the truth and the obvious. Politics, it's a question of getting it out of my committee, getting it out of the House, and getting it signed by the governor. But the second is a real problem. There are two real problems. One is, why do landlords let a lease run out? I mean, after all the landlord wants is a good tenant is paying. They don't want to kick out tenants who are fine tenants. The reason is very simple, and I imagine you can hear this from others. It's so expensive and so long and so difficult to evict a tenant that they just think, I'm not going to do it. I'll just live with it and I'll let the lease run out. Even if I don't get paid for 6 months, it's still cheaper, or 8 months or a year. It's still cheaper than going for eviction. So I think personally, that's the primary reason that landlords don't release. It's all they can do. I think that if we found a way to have an altogether different process, maybe we could figure a way around that. And I'm perfectly supportive of the idea of studying very carefully other court systems, like the Maine has a landlord-tenant court. I'm really open to that. But that's something that should be done carefully. What are they doing? How are they doing it? What's it look like? Would we do it? How much would it cost? Because it would cost. But anyway, we don't have that provision. And I have to say, if we were ever to look at these just cause provisions, I think we'd have to be very careful. Like, for example, in New York, the New York just cause, there's 4 states I know of, maybe more, that have these kinds of ordinances that say you can stay forever as long as you're paying release and paying rent. And they all have caps of some sort. In New York, it only applies to the named urban areas. The entire rural New York is exempted. I think, they recognize how difficult that is to impose on small landlords in rural areas. The other problem is, I think we'd have to think through is, there's a problem with rent caps. California, for example, has a rent cap. It's CPI plus 5, which means 8, 9, and maximum of 10%. Landlords under those regimes almost feel compelled to mark to 10% every year or 8 or whatever it is. And you have 3 years of that and suddenly you're a lot more. Plus, of course, once a tenant leaves, they can mark to market. And so there's, I think, an incentive that it's contrary to a good landlord-tenant relationship. It's sort of like, aha, you were smoking, you're out. I don't think that's a good thing. But I think all of that can be looked at. It's not in this bill. This bill is not that adventurous. We were just trying to do something that would work for both sides. The other thing we do for tenants, 2 things that I can right off the top of my head. One, what we do is, this habitability problem. Landlords, there are bad landlords, there are bad tenants, but there are bad landlords. One of the problems you have always when you're doing legislation is if you make it for the worst case, you tend to sort of mess up things with people who are in the middle, and you don't want to do that. But anyway, one problem is habitability, and landlords, it's just, like no heat or something like that. Believe it or not, there's a fair amount of that. Right now, if a tenant wants to do something about it, it's up to them to do something about it. They have to assert a habitability claim and stop payment of, stop payment of rent. There's all kinds of requirements. What this bill does is add a new way of dealing with that, which is to say, if a landlord files an action against the tenant for non-payment of rent, if they have an outstanding, uncured code violation that is serious, and we list what serious is, that's grounds for dismissal right there. It's the end of the case. It doesn't apply if the tenant caused the problem. And it has to be an outstanding problem at the time you file a complaint. But that's one thing we did. It's an absolute defense to ejectment. The second is, I think, for me, not so dramatic, but it's really important. Money. I guess it's my view, our view perhaps, that the best way to address the risk of homelessness, which is a difficult quantify. In other words, we know we have a terrible problem. Some people assert that shortening these times will cause more evictions. I'm not convinced that's true. There are studies to the contrary. It doesn't matter. We don't know. We don't know. We're just not going to know. But I guess our view is that if we want to try to prevent homelessness, the way to do it is through programs that do that and funding them, not by maintaining a kind of overly burdensome and kind of inadequate system that discourages landlords from staying in the business and reduces the amount of housing we have. And so that's why in our bill, as it originally came out before our appropriations committee got their hands on it, $1 million for the rental arrears program. That is an important program. It means it's run by the housing authority and it's authorized by us here in the legislature with a sentence or two, but it's mostly administrative, and I think will be loosened up a bit. But basically what it says, it's aimed at the tenant. who's ultimately capable of staying in the unit, but something bad happened. Like their car broke or was stolen, or they can't get to work, or they
Or
lost
they had a
their-
domestic
got
violence
sick.
situation, the apartment got damaged. We went through this because we put that in play.
Right.
And
And
this
so
piece
that,
is very
that they're gonna
important.
run out of money. In
Yes,
April,
it has run.
it's almost run out of money, and so we put $1 million in there for that, and that made it into our budget. But
It's so much.
there's other stuff we wanted to do. One is, we wanted, 200,000 for CBOEO to run programs for small landlords and tenants on what rights, responsibilities, and duties are. $600,000 to see, in order to have what I'll call kind of ombuds people, landlord, tenant, kind of mediators in all of the cap agencies, so that we just put, you see what we're trying to do, we're trying to prevent the eviction, trying to prevent the homelessness, if you will. And then, we put 100,000 in for the treasurer to run, remember the whole credit reporting thing. So that's,
Positive rental credit reporting.
Yeah.
so that's in there. I guess, could we do more? Sure.
Positive rental piece that came up earlier, we were curious, we're recalling why that didn't make it last time. Do you remember?
Yeah, I know,
Agreed.
why. You were stupid.
I've never.
We blew it.
Okay.
What happened is there was all this, remember it was in the housing bill. And then we had two housing bills here.
Okay.
Your chair and I thought we had it nailed down. We went back and forth and back. It literally fell out. It's all it was. So it's back in there. The treasurer wants 100 grand to administer it. Could we do more?
Sure.
And also, of course, then there's the whole issue of what are we doing about homelessness generally? And that's, the House has just passed a bill, which I think has a lot of good in it. It's not perfect. What haven't I said that I should say? Do you
I
wanna
just
add
want to
anything?
quickly, I want questions, but I just want to back this up, to remind your committee, I don't know if it's a Rep. Emily Krasno for the record, that, we had the landlord tenant study committee.
Wow, yeah.
We all have on our website.
Right, which I was chair of, and we produced a report. And as we know in this body, we want to follow through on the work and not just have study committees. So, this building for many years, I've been here since 2013, has been wrestling with this topic. And as Senator Robinson mentioned, she's had those. So this was really, we felt the time to tackle this issue because in our study committee, the status quo was found to not be working. And so our committee took a lot of time, testimony from we had 6 different bills in front of us, right? To blend, to come up with this. And as Chair Mahali said, this is not perfect for everyone, but it's what we came up with that we found to be the needs of both a step forward, because it's clear that Vermonters want us to act on this policy and that the time is now, and it's another thing to address in the housing crisis for various reasons. So that I just wanted to back this up in that. And so while we had the report that didn't come out with the specific legislation, numerous bills came out of the report information and made it on our walls.
We had 6 bills on our wall that we were looking at.
Pam mentioned that.
Yeah, I think they'll like.
So I
I
know,
have to finally just say, I've got to just say it. I feel a little bit like I'm with this bill, it's sort of like living on a razor's edge. Uncomfortable, but also kind of like, I'm not saying you shouldn't fill with it, be my guest, but just is that we were trying for a balance that each, and there's a lot of mutual negative fantasies on both sides of this. And when you have that situation where, you have such history, distress built up, the advocates on both sides. It's a difficult situation. There it is.
Keisha has a question, and I know Tom and David do as well. And I've got to go.
Hey, Keisha.
Hi, Mira, say hi.
Hello, Mira.
Hi, Mira.
Did you all look, so there's a mention of housing review boards, in the bill. I'm not sure if that came from Judiciary or committee. Housing review boards function in maybe a handful of municipalities as like a landlord-tenant court, a mediation environment for these very specific issues that touch many areas of the law and affect someone's basic rights to housing. Did you look at states that have a landlord-tenant court or ask for a housing review board to exist in most major municipalities? Did you, I mean, this is a lot of trying to affect the judiciary and not just giving them the resources to have a separate channel to manage these concerns.
One of the bills on our wall is to create a housing court. I guess my feeling on that is, first of all, I think it's a really interesting idea.
Yeah.
I don't think it should be done lightly. And for example, if let's say you decided you wanted to study it, we'd want to talk to Maine in depth.
Right.
That is Maine practitioners on both sides, the main, people who run the court, what their budget, if there's going to be a real budgetary impact. One of the things I find, I'm speaking for myself, not like you did, I find attractive about that idea is the possibility that we really just change up the whole process and make it, a better process for everybody, and that we fund advocates for tenants that aren't necessarily legal aid. I mean, I'm a lawyer, but it doesn't have to be lawyers.
Right.
It can be specialists who are just available to are less expensive alternative, to navigate the process. So, Keisha, I think it's an interesting idea. It was before us. We don't feel like we prioritize the things that I suggested to you about funding that was directly aimed at the homeless. We didn't want to we just didn't think we had the resources right now for a court.
Well, and I think in all fairness, we haven't done the work of figuring out what it would look like, and we should take the time. But I think putting in a study, a task force to actually address it would be a
I
great
would
idea.
love that.
So if I could just say, I mean, the bill really impacts the court by putting timelines in that you're expecting they can accomplish emergency hearings and, affect people's really basic rights based on what sounds like hearsay about activity in apartments that might affect the health or safety of individuals. That's going to have a huge impact on the courts without any funding in this bill, is what I understand.
Tom, I believe they addressed this, but Zone signed off on all these timeframes.
Yeah,
I just have to go up and do another talk.
I do want to mention, I don't think. First of all, Judge Zone, you should have Martin Lamont here. And he'll tell you
Well, we
what-
should also have Judge Zone because I don't know what it means to sign
but-
off on these time
But,
frames.
I think that it's quite likely that if they run into trouble, we're going to see the timeframes not change that much on the ground. I just don't know, but it is.
If you looked at how things are being done here, how they're being done in Maine, did you look nationally at how things are done, and does anybody get it right now?
I think we know, and we had testimony on what's happening in California and Oregon and Maine and New Hampshire and a few other states. I wouldn't call what we did a thorough looking at whether they quote unquote got it right. And one of the problems is in order to decide whether they got it right, you can't just hear from the judge. You got to hear from the landlord attorneys and from the legal aid or the other defense advocates, and you're going to likely hear different stories. It's not impossible, but it's
Well, there
not
certainly
easy.
are nonprofit groups that represent both parties that are national in nature.
Right,
Did
there are.
you reach out to them, for example? Because that might be a way to at least get a picture, because this is not an uncommon problem nationally
No,
and certainly in every state.
I would add that I don't think it changes anything. I will say, Keisha, I don't think anything changes from the due process perspective, because just by allowing it to be initiated by a landlord by a sworn affidavit doesn't change the fact that the court has to find that there's adequate proof.
Mhm.
And so it means that the landlord has to make the case, the tenant has to reply, and whether they do that orally or through in writing doesn't change anything. It's just, if it's alleged that it's a dangerous tenant, then you're gonna have a faster process, but it's no different than the existing process.
I mean, no trespassing someone from a place they might be on the lease, is a big change.
The no trespass ordinance applies now to someone who's on the lease. What we added, and that's current law. What we added were two things. One is we added a provision that allows the trespass laws to be aimed at someone who is no longer on the lease, but is a danger to other tenants. But the other is, we added a whole long provision to deal with protecting the victims of abuse. Here's the problem. What's the landlord do? What does the landlord do if there's the dangerous person is on the lease? And let's say it's one of the members of a pair of people, and they're beating up on the other pair, but also other tenants. What do? Well, right now, under current law, they only have one thing they can do. They can eject, right? But that means you eject the victim, right? If it's an abuse situation, you're ejecting the victim. So
No, that's a relief from abuse order process.
right, but in
That's,
addition to that, to protect them, we gave the tenant the right to divide the lease. And then the landlord could just eject the perpetrators. That is not an existing law.
Well, Mark, where we are right now, we've got about 4 minutes.
Sorry, I took so long.
Before we have to break and be on the floor.
Right.
So if I,
Oh,
by virtue, right, but by virtue of the role that you're playing, of kind of bringing us up to date of the issues that you face, the problems that you face, how you dealt with them, and the end result, is there any way that you want to summarize your recommendations to us?
I think that overall, it's a good package. I think it's a start. I think that there are some major things that we could think about in the future, but I think they need some study, and this is a good base start with. It's giving tenants, I would seriously consider the funding that we lost in our appropriations. I think that funding for preventing homelessness is really important.
What was the
Not-
amount involved? What was the amount involved?
Well, 1 million plus 100,000 plus 600,000 would be 2.7 plus 2.9, no, 1.99. So, that's otherwise good luck. If I can be of assistance in any way, I'm happy to do that. I'm happy to do that, and remember, in this situation, everybody's right.
Any particular people that you think we should hear from that you want to bring to our attention? Very,
Well, there's no one that you wouldn't obviously hear from. I mean, you're going to hear from the URA, you're going to hear from CBOEO, but you're also going to hear from the Vermont Landlords Association. You're going to hear from the nonprofits like Champlain Housing Trust. They're one of the biggest landlords. I think that you'll get a pretty good picture there. I think talking to Judge Zoni, but I do think if you're going to listen to Judge Zoni, you should listen to Martin. Well, I really think Martin ought to be before you, because they had a lot to do with what's in front of them. And they were great. They were really great. They were really good. They made it better.
well, again, thank you very much for coming down. That's been very, very helpful, and
Good. Thank you guys for even taking this on.
Before we adjourn, for the day, we go upstairs. Anything, anyone wants to bring up, Keisha? We are adjourned for the day. Thank you very much.